Very excited to be joined by this amazing panel of turning compliance into opportunity and getting ahead of regulations. I am joined by Nat Rosasco, Kristine Schachinger, and Steve Kuncewicz. I apologize profusely if I mispronounced any of it. I'm actually going to have each of you go around and share a little bit about yourselves, why this topic means so much to you, and then we're going to dive into Steve's amazing presentation on the specific legal compliance pieces, Nat's amazing presentation on how to think about it as an agency, and then we'll have the joint conversation joined by Kristine following that. So Steve, do you want to take it away?
Yeah, I'd love to. Hi, everybody. My name's Steve Kuncewicz. I'm a lawyer, so yeah, sharpen your pitchforks. I get to work with agencies every single day, and I'm the head of the creative, digital, and marketing department at a law firm called Glaziers.
And Nat?
Nat Rosasco. I'm the founder and creative director of Olive Street Design. We've been with Duda since about month one. Built a couple thousand websites with them, and ADA compliance has been on my radar for over a year, and I think it's really important, and I'm just ecstatic to be a part of this.
And Kristine?
My name is Kristine Schachinger. I'm a consultant, mostly specializing in SEO, technical SEO. I've done accessibility since around 2004 and was fortunate to be trained by one of the people who helped write the CAG standards. Worked for the federal government for 3 years as a accessibility lead, and then still use that work today with my clients. So.
Amazing. So Steve, tell us all about what we need to know from a legal standpoint. I know you in our prep sessions would say this is the bit that counts the least, but I'd argue this is the bit that counts the most. And everyone definitely put your questions in chat. We'll be keeping an eye on them so that we can have that group Q&A conversation after both sessions.
No, that's awesome. Thank you, Navah. I mean, I'm just used to the lawyers not being the most important people in the room, and we shouldn't be. But I'm going to try and give you an overview of what you need to be thinking about from a compliance perspective in about 15 minutes, if we can. So I don't know, are the slides going to pop up?
You need to actually present the slides.
I can present the slides. Okay, in that case, I'm going to fluff for time for just a second until I can present the slides, which won't take me one moment. But compliance is it's a big deal. It's always been a big deal, but it's becoming a bigger deal recently, partly due to ADA compliance and partly due to a number of other bits and pieces of compliance. Notably in the EU, obviously we've had GDPR. GDPR has been an ongoing movable feast of compliance that is actually pretty straightforward. It's been an aspirational thing for years and years and years, and then all of a sudden we've had people emailing all of my clients saying you need to do this or you're going to get sued into the ground or fined out of existence. So it's been compliance that has been driven by kind of necessity, but also there is a load of opportunity in it, or at least I think there's a load of opportunity in it. But I would say that because I'm a lawyer and I provide compliance services. So if we just bear with us for a second or two while the slides upload again. I know we uploaded them over the last last day or so, but I'm going to start talking to them anyway because we've only got so much time. We want to make sure that everybody has their time talking. So what do we need to comply with who and why? Well, I'd say there are two big groups of people that we need to think about complying with when putting the sites together. Clients in particular, and we're going to, oh, there we go, there are the slides, which is handy, so I don't need to riff anymore, yay. So again, who do we need to think about complying with? Clients, we need to think about complying with them because you sign contracts with them, and they will sue you if things go wrong. And regulators around the world, whether that be people like the FTC in the States or the ASA in the UK, the ICO in the UK. Each of these groups have different expectations and different ways to make your life difficult. Clients, more importantly, are going to push their compliance obligations down onto agencies, and they are going to hold you responsible for delivery of projects and campaigns and builds. Potentially, they're going to do that in court as well. And regulators can fine and enforce normally your clients, but in occasional circumstances you, and they can publicize their decision. So as I said before, it's no longer an aspirational thing. It's also an increasingly globalized issue. But the common themes I think we see at the moment are, we're going to talk about this, Nat's got a fantastic presentation on this, accessibility of sites, privacy, certainly around GDPR, things like the CCPA in the States, and online safety in the UK, a really controversial piece of legislation, the Online Safety Bill that is currently making its way through the UK Parliament. And then, of course, there's the public, there's the audience. We are going to talk a little bit about legal liability because increasingly, certainly in the States, we are seeing group litigation over the ADA. We haven't yet seen something similar in the UK under the Equality Act, but it's not a million miles away from happening. So having said that, and moving on to the next bit, regulations and regulators. So big issues we've already talked about. I'm going to touch on AI just a little bit because there is only a little bit of idea as to how the use of AI is going to be regulated. Certainly in the UK, there's loads of law that already applies to how you can and can't use AI as part of builds, as part of any kind of campaign activity. Each territory is pursuing a different approach, and the UK's approach at the minute is kind of because we don't have one. The idea is that we've got a lot of law that should sort us out for the time being, and the UK certainly wants there to be a pro-innovation environment through which AI is used. But for now, certainly IP law, data protection law are doing the heavy lifting, because when you're thinking about generative AI, the worry is that you're going to be effectively lifting content from all over the web, which could be exposing you to huge infringement risk. And again, data protection, you could be lifting content from all over the web that could be used in a way that leads to privacy concerns. Notably, EU and UK data protection law is extraterritorial. So if you're doing anything that relates to an individual in either the UK or the EU, you are going to need to comply with either the UK GDPR, which is our retained version of the GDPR, or the GDPR. And that is supported by a load of significant enforcement powers. You'll have heard about them. You'll have seen them, fines of up to 4% of global turnover. Then we've got advertising regulation. There is a system in the US that is a bit more stringent than the UK. And in the UK, we've got a self-policing, self-regulatory system that deals with website content specifically, that's backed up by consumer protection law. And then we've got accessibility. Again, Nat's going to talk about this in more detail, but the basic UK position under our equality law is that websites need to be accessible to everybody and not discriminate against particular groups or communities based on protected characteristics via the adoption of what we refer to as reasonable adjustments. The way that's dealt with in the UK is similar to making a reasonable adjustment to let somebody get to a cafe, say, if they're wheelchair bound or otherwise disabled. So it's a classic example of law trying to catch up with tech. We've got electronic communications and intermediary liability to think about. Online safety, again, different countries around the world approaching it in different ways. The UK has a stated aim of becoming the safest place in the world to be online. I have no idea how we're going to get there, and anybody who spends any time on social media in the UK may tell you that they don't find it particularly safe. But if the online safety bill does get passed, then there's going to be a new duty of care on businesses that fall in scope, which can include certain sites, can include platforms, to make sure that they do what they can to deter harm being caused to their users. And that also includes disinformation. So in election season, both in the US and the UK, that could prove particularly interesting. Again, that's extraterritorial. And compliance with regulators, again, as I've said before, is often seen as the client's problem. The worst they can do is sue us. If the clients get in trouble, it's up to them. That's not necessarily always the case. In the UK, as part of the CAP code, which is the advertising regulation, agencies still need to do their bit to comply with the code, just the same as the clients do. As far as data protection goes, you may be what's referred to as a processor of personal data, so you don't decide how it's gathered or what it's used for, you just do things on the client's behalf. But they do have their own obligations. They can be fined, they can be sued in their own right, although the risk is far lower than it is to clients as controllers. And at the end of the day, we don't want to see you become lawyers. It's tempting sometimes, I think, to work with clients to give them ideas and to give them advice and to have them lean on you for things like brand clearance, for example. But the more you take that risk on, the more the client is going to expect from you, and the more risk there is that they're going to say you've given them the wrong advice. And I'd say if clients do expect you to weigh in on these kind of things, then they should pay you to go away and get your own legal advice so you can pass it on to them. Apart from that, ESG is becoming a major issue of clients and their agencies, but obviously it doesn't apply specifically to builds, doesn't apply specifically to projects. As far as accessibility goes, there are some principles incorporated into EU law. Adopting them are going to help you to defend against litigation here. In the UK, there's been a focus on accessibility and some specific rules put into place when you're dealing with public sector websites. US compliance with the ADA has been brought into focus, as I mentioned earlier, as a result of a massive increase in consumer litigation in class actions. The UK position under the Equalities Act 2010 requires, as I mentioned before, website owners to make reasonable adjustments to make them accessible to everybody. We've yet to see any litigation in the UK on this particular point, but we have, funnily enough, seen some litigation, well, not funnily enough, from the Royal National Institute of the Blind that has pursued claims similar to this, but we've yet to see any case that deals with what's going to be a reasonable adjustment in terms of website access. And the Americans with Disabilities Act Title III in the States deals with disability discrimination, again, in a similar way to the UK and the EU, in public-facing businesses and commercial facilities. Any website accessibility fail can and is increasingly leading to a claim in the US. The EU position is all set out in the European Directive on the Accessibility of Websites and Mobile Apps that sets some common standards. And it's a major client issue, largely because they're going to have to provide an inclusive service, or they'll want to provide an inclusive service to the largest possible audience. But it's also based on legal requirements and all based on the Web Content Accessibility Guidelines, the WCAG. That's by far the most prevalent digital accessibility standard that's administered and published by the World Wide Web Consortium and the Web Accessibility Initiative. For principles, your content on a site needs to be perceivable, operable, understandable, and robust. That's underpinned by guidelines and success criteria, not too dissimilar to the way you may look at a project plan or agreement with your clients. They give you specific compliance requirements, and there are 3 levels of conformance and 5 requirements for that conformance. Meeting the relevant level across a full page or a complete process enabled by accessibility use of technology or without interference is going to get you the highest level of compliance in particular. So similar kind of approach around the world, but definitely brought into focus mainly in the court in the US. As far as privacy and data protection goes, there's a much bigger concern among the public around use of personal data than ever before, and as such it's a much bigger issue for clients because it's the kind of thing that can get them sued when things go wrong. We've seen all sorts of class actions based on privacy fails in the States, and we have seen a fair few in the UK. Interestingly, some of the bigger class action cases have failed for various technical reasons in the UK, but we've also seen some very, very hefty fines handed out by the Information Commissioner, mainly based around when marketing tech goes wrong. A particular example of that would be when the chatbot that Ticketmaster in the UK used was breached. The US position as far as data protection goes is that there's no general federal legislation to deal with it. It's largely dealt with by states, such as in California by the CCPA. Enforcement is carried out by the FTC, but there's no requirement for a business to have a nominated data protection officer. If you are involved in any kind of personal data breach that involves more than 500 individuals, you need to notify the FTC. And if there's a breach involving sensitive information, such as health information, for example, that needs to be notified to affected individuals. You don't have opt-in consent, or you don't need opt-in consent for cookies or tracking tech in the US, but certainly if you are using that kind of tech, notice of online tracking needs to be provided along with a method to opt out. The position is a bit different in the EU and the UK, and it's handy that it is the same until the UK diverges away from the GDPR even further, which is probably going to happen over the course of the next year or so. That's covered by the GDPR, the UK GDPR, which basically where we ported the whole thing over after Brexit, and the Data Protection Act 2018. That's enforced by the Information Commissioner's Office and EU regulators. They have various notification, informational and fining powers. We do need data protection officers in certain circumstances and certain categories of personal data breach where they have an effect on the rights and freedoms of individuals do need to be reported to regulators. Again, if there's a breach involving a high risk to those rights and freedoms, then they need to be notified to the affected individuals. We do need specific opt-in consent for cookies and tracking technology, unless it's a strictly necessary cookie or used solely to transmit communication over a network. And there are restrictions on data transfers. There have been restrictions on data transfers into the US recently until a new workaround was found based on the idea that a location has what's called adequacy. By far in the EU and the UK, the biggest compliance burden is on data controllers. I mentioned before, that's the body, normally the client, who decides what data is collected and what purpose it's used for. If you do anything with personal data on behalf of a client, you are a processor. And it's worth bearing in mind that the concept of personal data is really wide-ranging. It's defined in our law as pretty much any information that relates to a living individual, which includes a cookie, which includes data related to an individual via tracking, gathered by tracking tech. There's a number of principles you need to follow in the UK and the EU, whereby you're expected to process personal data lawfully, fairly, and transparently for a specific purpose, only take as much as you need, only hold it for as long as you need to hold it in the first place, ensure that it's accurate, ensure that it's kept confidential and secure. And interestingly, over here, we have a seventh principle, which is the accountability principle, where you've got to show that you have policies and procedures in place to show that you take this seriously. And again, if you are dealing with EU individuals or UK individuals, this is extraterritorial, you'll be expected to comply with this. It's also worth noting that as far as the rights of individuals in the UK and EU, data subjects, that's individual to which personal data relates, have the right to be provided with information about where their data was collected from, what's done with it. They're allowed a right of access to that personal data or copies of it, a right to rectification when their personal data is inaccurate, a right to erasure of their personal data in certain circumstances, a right to their data being restricted in terms of how it's used and objecting to how it's used, and around automating decision making. So all of this will need to fall into the criteria of a project, and this needs to be planned for. I'm no doubt that Duda already does this, but clients will expect you to help them comply with this. And again, help you comply with this if you're doing anything in relation to anybody based in the UK or EU. So as far as clients go, contracts. Why do contracts matter? Well, plan in peacetime, because it's cheaper to do it when things are going wrong, when everything's on fire, or when you're under financial or other pressure. Absolutely, the cliche is true here. An ounce of prevention is worth a pound of cure. And more importantly, once you've agreed a client, once you've completed a contract, renegotiating terms is not easy. Get your team of advisors is right, is crucial, not just lawyers, but your insurer and your accountant. Build a partnership with them over the long term. And money isn't the only motivator in a project, but it does need to change hands, so do plan for it. Usually when you're looking at an agreement with clients, only a few clauses really matter. The rest of it is boilerplate. The rest of it you'll see in every single contract. But knowing what's important to you is really important, namely who's going to own what you build, what the financials are, what you do in an exit, what happens when something goes wrong, when the client can terminate. Don't be afraid of longer agreements, even though short form heads of terms and deal memos can do a lot of heavy lifting for you and allow a project to get underway while you're agreeing the longer agreement. But to me, contracts are all about knowing what you're worth and what you want or can deliver or need. Have difficult conversations with clients early when things are going wrong, and do plan for the future. Don't take any project, don't take any deal. Think carefully about what kind of rights you're willing to give away. Sweating the small stuff now is going to mean that bigger issues take care of themselves, at least on the legal side. And contracts and their strength are going to be key assets of your business. It's really easy to be persuaded in signing up to a client's contract just to get a project, just to get the work. They could be full of bear traps. They could be full of compliance requirements. Things to look out for: how long does the contract last? When does your obligation end? Is it when the site's delivered? Is it when the project's delivered? What do you do about user acceptance testing, A/B testing, creative control? When does the client sign that off? How much input do you want from them? What's the standard of the work you do? Is it just the UK, EU standard of reasonable skill and care? Do they want good industry practice? Do they want you to comply with applicable laws, which could be pretty much anything? You will need from clients prompt sign-off, proper cooperation, access to information, people and services. You'll also need that from third parties in certain situations as well, maybe design teams, other parts of the creative team at your client. When you have a meeting, do you want to report back on the outcome of that so you've got a written record of it? What happens if your project gets rejected? What happens if things aren't right? Do you redeliver? Do you refund? Do you have certain situations where you're dealing with really big clients and they'll say, well, if the project doesn't go as planned, we can get another agency to deliver it and you pay their fees? That's becoming more and more common, especially with big institutional clients. When do you get paid? Is it in advance? Is it a minimum guarantee? Is it over a staged set of payments? And on whose terms? Can they dispute your invoices, or do they have to pay come what may? Do they pay the balance in an interim? When can you start work in the event that you haven't been paid 2 or 3 installments without a client saying that you're in breach? They may want to come and look at your records of time spent on a project or inspect your data protection compliance. How do you want that to work? Is that going to be on notice so they don't disrupt you? Again, who owns IP? Who owns what you build? If you're bringing background IP to a project, you need to keep ownership of that, but the client will want to be able to use it. And they will ask you for an indemnity. They will ask you to pay out in the event of a claim of IP infringement as a result of the work you deliver for them. You'll want the clients will want to take the lead in those claims, but you want involvement. What do you do about confidentiality? You'll be given a lot of confidential information as part of the project. Clients may want the same people in the project all the way through. Can you agree with that? What do you do around data protection? How do you limit your liability? Do you limit your liability to the value of the project or maybe a percentage of that? How does the client get out of the agreement? Is it just in the event of a breach, or can they walk away, say, after 6 months? What do you do in the event of an act of God? Acts of God, force majeure, have really been brought into clear focus again post-COVID. And what does an act of God mean? And when you're dealing with international clients, governing law in jurisdiction, which law applies to your project? So having said that, seems like a lot of hassle, right? Where's the opportunity? Well, doing the right thing's worth money. It helps to secure relationships and projects. And having a view over the risk landscape helps you manage projects and helps you manage client expectations, because compliance sometimes has to inform creative. It saves on wasted pitches, saves on wasted ideas, and avoids disappointed clients. And it's worth doing the work now to think about compliance to avoid problems later on. The opportunity, in my view, and Nat's going to talk much more about this, lies in saving money and time, avoiding disputes and potential regulatory sanctions, and protects your brand, protects your reputation, protects your revenue. That's a whole lot of talking. I've had a whole lot of coffee today. It is late in the UK. If anyone wants to contact me, I'm sure those details will be made available, but I think that's enough of me for now. And I'm going to throw over to Nat, if that's okay.
That was an amazing session, Nat. Ready to take all of that legal and turn it into here's the action plan for sales?
I'm ready.
All right, Nat, take it away.
All right. There we go. Wow, I got it. Steve, thanks for showing me up by putting on a suit jacket and looking very smart today.
First time for everything, Nat.
Yeah, there you go. So I've been reading kind of the comments that are going on here, and mine is kind of the poster child for this, the 88 compliance, because this was on my radar a while ago. And this turned into something, the more I looked into it, the more frightened I got. Steve's going through all this stuff. We turned to our legal team. I was like, the more I looked, I was like, oh my gosh, this is unbelievable. So this is how we turned compliance into an opportunity. And it's very straightforward and it's simple, but it's a footprint and a blueprint for doing what we did and the success we've had for this. So early January, we got a phone call from the University of Florida. They had been sent a letter from a national ADA organization, which was the good news. It wasn't from an attorney suing them and wanting an immediate demand letter. Well, we looked into it and we were like, oh my gosh. Well, in that same week, we got 3 other calls. And we started thinking, maybe this thing is important and we need to figure this out. And we just were looking at it from our client standpoint. We got the University of Florida, and we had some public universities and places that were going to be on the radar. A lot of voting election counties in Florida. And we contacted all our government clients, and they all added accessibility. I'm like, all right, good. We've done our part here. We've gone to our 8 or 10 government clients. We did enough. Well, was this enough? Started nagging us. We're talking about, should we pursue this further? What exactly is website accessibility and why does it matter? Who does it affect? This is a slide, I believe it's from the AudioEye website, but there are people that are blind, motor, mobility, color blindness, epilepsy, cognitive disorders. There's a lot. It's a lot of people. And we started thinking, you know what? I don't know that we did enough just going to the Seminole County, Florida, and putting accessibility on their website. You know, we've got a whole lot of clients here. So we kept going further. Time to ramp up our efforts. Here's we contacted our lawyers here in Chicago and said, you know what? Why don't you start looking into accessibility, website accessibility, and lawsuits? And what we found was I have reams of lawyers will do. They sent me reams of more information than I knew what to do with. And I started reading it and getting more and more nervous. So last July, we went to Louisville for a DUDA event. Ty Demore was there from Audio Eye. Good friends Justin and the team were there, Oded. And we spent a lot of time talking about the software, the lawsuits, what we're doing and what we should be doing. And it really ramped up what we wanted to do. So what did we do next? We came up with an email campaign. Our attorneys, the Audio Eye executive team came into play with this. We got a new registration with PandaDoc. The key to this, and this was the key. This is from our attorneys. This is from the Audio Eye people. This is from Justin at DUDA helping us out. We had a really slick letter that talked about website accessibility, what it is, why you should do it, why it's a good thing. But at the bottom of it, this was the key. And that's why we did it through PandaDoc. Now, we tried to sell accessibility for the previous year. We had 11 that we had sold. This was a thing that sold it, is they had to click on there, opt in, continue with our recommended compliance solution. Yes, I would like to continue using ADA compliance, $39 a month. I understand all external documents not covered. But the next thing was the thing that got them shook up. I choose not to be compliant and assume legal risk. No, I do not wish to add ADA compliance and data privacy on my website. I understand my website does not meet the most recent ADA requirements for website access, and we cannot be held responsible. A flurry of emails and phone calls came after this. What is this? What are you talking about? They really didn't care, because I'm looking at the comments that were coming in. People didn't know it. They didn't know much about it. It was subtly on their radar, not really. They didn't know what it was. In fact, we had a couple people call us and said, we don't need to be ADA compliant. We don't have a brick and mortar facility. They thought they needed ramps to go into their office. I mean, that's how little people knew about this. But when they understood that I was nervous, that I didn't want to get sued, they thought, maybe this is for real. And that's what turned the corner with this, is these couple little things here. And then they called me and said, well, we don't want to be compliant. I said, that's fine. Click the PandaDoc, because I want this on record for our attorneys down the road. And they're like, oh my gosh, it turned the corner. So time to educate our clients. Here's just, this is one of our websites in the ADA, for what it looks like on the website. But this was in the email that I put in there. We want to foster inclusivity, demonstrate commitment to inclusivity by providing accessible online experience to everyone, mitigate legal risks, minimize the risk of legal actions and lawsuits. And this is for our clients and ourselves. Enhance user experience. So we started talking to our clients about this, and we came up with another email that talked about these things, and that the bonus that you get a marketing and brand loyalty boost because of this. Results so far, and this actually, it's a little, and here's the University of Florida, same website with our little icon in the bottom right corner there. It's actually, now we're up to 192 clients signed up for accessibility at $39 a month. This has changed our world. I also saw in a couple of the comments there, is there a free version of something? I'm not going to legally talk about this, but all I know is when our attorneys looked at it, they also said, by your clients thinking that the free widget is the same as a paid one, it isn't. and that's we're going to throw the UserWay free widget on all the websites, and it actually can give you a false positive and get you into trouble. So, and again, this is from me rewording stuff from our attorneys, but we wouldn't touch, we'd put the UserWay, the free one. There's nothing wrong with UserWay, great company. We took it off the sites right away because people think they're ADA or web accessible. They're not to the level of the paid version. So I couldn't pay that quick enough. And the lawsuits so far, we're hearing they're between $10,000 and $25,000 to get out of the lawsuit. And I also, one other interesting thing, I got an email from another company yesterday because I'm like Mr. Accessibility now. It was from a company that does website accessibility that is not in a widget like this. And you're thinking, oh my gosh, why do I have to pay this? This is more money. I got to pay this to Duda, who pays it to AudioEye, whatever. They sent me a list of what it costs to do that with accessibility that's not a widget. For a 20-page website, their price was $10,000. And that was to an agency that they knew we had thousands of clients. So I'm thinking, you know what, for what we're being charged for this, it isn't a bad deal. What did this accomplish? Build trust with our clients. I got 75 or 100 phone calls saying, oh my gosh, this is why we like, I'm not promoting myself. It's thank you for doing this. We didn't know about this, but we did it in such a way. We gave them all that information that no one had ever given them. According to the WHO, 1.3 billion people have a disability. It's time to embrace this segment. Brand enhancement for the client. And lastly, but not most importantly, is it protect your agency. Here you see there's California law, and it's talking about, it gives agency clients the right to sue their agencies for creating inaccessible websites. They get sued. Who do you think they're going to call first? Oh, they're going to call us. They're going to call the agency. And what did this accomplish? Lastly, most importantly, it's simply the right thing to do. All this other stuff is that's what you should do. That's all I got.
That's all he has, you say, with that amazing, amazing session. Oh my goodness. Before we go into general Q&A and conversation, and I saw a ton of amazing resources there. Kristine, we want to have you start the conversation with a couple of examples just to demonstrate what good compliance looks like and what maybe not good compliance looks like. So Kristine, if you want to take it away.
Sure. Just to add to what Steve said earlier, by the way, there is a bill in Congress called the Website and Software Applications Accessibility Act that has not been voted on. And if that goes into law, then it's not just making the ADA fit accessibility online, it'll be, you have to be compliant online. So if you're a large company, I would make sure you follow that, because the minute it goes into effect is when you could be not just like, we're going to make the ADA fit your site. We actually have a law now that makes it so you have to be compliant and that you have to have your accessibility set. So that's a really important law, and hopefully it might pass next year, they say. So hopefully. So I started in accessibility around 2004. I did the United States Fire Administration website, and I just found it so important to people with disabilities. I didn't know at the time like how difficult it was, and that's way back when the tech was really bad. And then I was the director of technology for a company starting a startup, and the boss came to me and he hired me because of my accessibility background. And he said, well, why should people do accessibility? And I said, because it's the right thing to do. And he goes, no, I can't sell that. And I go, okay, because legal reasons. He goes, no, I can't sell that either. He goes, I do startups. I'm very good at it. I can tell you no one's going to buy it because we're going to sell accessible websites to the flooring industry. He's like, I can't sell either of those. No one cares. He goes, I'm sorry. He goes, it's the cruel part of the world. No one cares that it's the right thing to do. And no one thinks you're going to get sued. So now the climate's a little different today, where you have a lot of lawyers that are kind of like, it's the new ambulance chasing, right? So what he said is you have to make a business case to the company. You have to make it worth their while. And so I have two examples, one where they didn't do it and one where they did. One is, if you know the Wynn Las Vegas, Steve Wynn, who's no longer running any of that, is blind. He has macular degeneration. He's legally blind. My friend was the director of marketing there. He wanted me to do an accessibility audit and then help them create an accessible website. At the time, we did the research and found out that was a $13 billion travel market, and Vegas was one of the top 3 cities that people traveled to when they had disabilities because we were such a new city. We presented that to Mr. Wynn, thinking because he's blind, of course, he would like to have a website where people could use it, right? He did not. He did not care. They took the website. My friend left soon after. They took the website down and they put up these big buttons because that was supposed to be for people who had visual issues. And they took down the flash for people who had reader issues. None of it was accessible, right? But the big point of that is he missed out on a market that was billions of dollars, right? Because he wouldn't accept that this is important for his business. Then I worked at Zappos. Zappos has a whole grouping called Adaptive. And Zappos uses a lot of internal data, and it lets its customer service people stay on the calls as long as they want. One went for 20 hours one time. And what they did with that data, what they learned from their customer service people is what people needed in the market. So, you know, nowadays you have the easy slip-on shoes advertised everywhere. The big push of that started with Zappos and one of their people telling them that their son with autism couldn't find a shoe that he could wear because he couldn't tie a shoe. And then they started looking into the fact there are people that need one shoe and they got this from their internal data, what people were searching for, what people were calling about. And of course, at the same time, they're also working on website accessibility. But so now they have a whole line in Adaptive that adapts to a whole line of people with disabilities. And this is worth hundreds of millions of dollars over the course of the market, not necessarily just to them. But so people dismiss accessibility because they don't want to do it because it's the right thing, and they don't want to do it because it's a legal thing. It's a really smart business thing. There's 60 million people in the United States who claim disability status. That is a lot of people with disabilities that can't read your website properly or can't get a product from you because it doesn't fit right or doesn't work right. So I tell people when they talk about accessibility, it's just smart business to do it. And also, if you go into SEO, while Google doesn't have the accessibility standards written into the ranking signals, everything you do to meet the accessibility standards helps you meet ranking signals you're probably totally unaware of, but will help your website. And then also it makes your market, it opens your website up to a market that you may not know even exists. A dark market, like in travel at the time, which was $13 billion of people buying travel who had no ability to book travel because the websites for hotels were so atrocious at the time. There was literally no way to get on there and do that. So that's how I opened the discussion, is that it's great to say you legally should do it. It's great to say that you should do it. I agree with those things. But for business owners, the best thing is to make a business use case of why it matters to their company.
Awesome. So I will put it to Nat and Steve. Which of you wants to kind of field this first? There were a number of really powerful comments about how much to invest early versus later, and how many people are currently not thinking about it. So it could honestly go to either of you because both of you touched on this. But okay, Steve, well, go ahead.
I don't want to steal Nat's thunder. I mean, the UK perspective, I think, has been that the Information Commission has spent a fair amount of time going around websites and looking at privacy notices, you know, which is the bare minimum that you need to explain to people what you do with their personal data. And still, there are so many websites not getting it right. You could talk about the design imperative to reach your widest audience possible, but I think we are still seeing in the UK the fact that, you know, the bare minimum is not being achieved. Where we've seen, and I saw the mention of a predatory lawsuit in the comments quite rightly, we've seen a lot of that in the UK, not around accessibility, but around cookies in particular, around the application of the privacy and electronic communications regs. And we've seen an awful lot of cell-style privacy activists going to sites, finding non-compliant ones and saying, right, okay, you don't comply. I have suffered distress as a result of that, even though now in the UK courts you need to have medical evidence of that distress. Give me £750 and I'll go away. And this makes them an income. And it is, but we talked about lawyers doing up the sneakers to chase an ambulance before. That data protection privacy legislation has absolutely been the ambulance of choice in the UK for quite some time. And getting that right is just about having wording on a website. You know, getting accessibility right, again, and having worked in-house at a very large e-commerce retailer, why wouldn't you want to do it? You know, do it now and avoid problems later. It normally tends to be less expensive than you think. And if you've got a solution like Nat's available that is built by the community for the community, with lawyers kind of sat in a cupboard, you know, occasionally advising, I don't know why you wouldn't want to buy that.
And some, I'm sorry, I was just going to say, some people help design and build websites, and retrofitting is always more expensive. And so if you design it, a new section of the site or a brand new site with accessibility in mind, then you're opening yourself up to more markets, you're keeping yourself protected from lawsuits, and you're not going back later when the Department of Justice here in the United States sends you a message that your site's not compliant and now you have to fix it, or they're going to take you to court and fine you. So it's really important, I think, to start very, very early and get it just put into your plan that this is what you do whenever you work on your website.
So Nat, before I go to my next question, do you have any thoughts on that?
Yeah, we thought that this was an urgent thing, and you know, dude has got all kinds of new apps and things going on in the store. This is the one we got behind and said we have to stop everything else we're doing and get all over this thing. For all the reasons that I mentioned earlier, really, we don't want to get sued, and we make some money. You know, by the way, we help our clients out. But if there's one takeaway from every agency that's on this call, is I would do whatever I could when we get off this call and DudeCon is over, is to do this right away and protect yourself and do the right thing for humanity.
So one thing I do want to get to, and then there's a really good question for Kristine. One of the things that stood out to me, Nat, in your presentation was how well this was packaged. And I think you did a beautiful job of sharing with everyone kind of what that package looks like. If people are trying to figure out their own packaging system, where would you suggest that they start? Should they just templatize what you've put out there and go from there? Is there kind of more thought that needs to go into it? How would you suggest approaching it?
Well, I did put secret sauce on the beginning of that, so that's our secret sauce. I think I shared a lot of things, and I think I spent a lot of money with lawyers, and I think what I shared is really the blueprint for people to take those pieces and put their own together. And you know what, just give me a attaboy at the end of the day, because we showed the different things you need to do. But I said a well-written email, putting that opt-in and opt-out legally, doing it through something that's kept into, that's saved, so for later you get that. Those are the steps. I did the 1.5 years of work and shared, really, if they follow those steps, they have it.
So Kristine, there was a good question from Justin Copeland around the name of the legislation. Would you mind going over that again, kind of the main points that people should think about?
It's called the Websites and Software Applications Accessibility Act. It was introduced by, I believe, Duckworth. And I can give a link to the actual congressional tracker if you want. I can give it to you now if you want to put it in the chat. And
or you can put it in yourself.
Oh, okay. I didn't. It said I can join chat. Hold on. Sorry, guys. I didn't know I could join or not. No, it wants me to connect my YouTube account.
I think a bunch of us. Now I'll put it in.
And then here's a good explanation of it from accessibility.com. I'll send you that as well. So basically, because the ADA does not, a lot of people say ADA compliance, which is kind of a misnomer, because the ADA doesn't have a specific section that says, unless you're working with the government, and if you're working with the government, then yes, you do have to be accessible. But if you're not working with the government, you don't have government contracts, there's nothing that says that I put up my website today have to be accessible. Just when they sue, the lawyers sue, they use the public forum aspect of the law or a couple other aspects of the law, the Title III that Steve mentioned, to sue on. So it makes it harder because it means it's very judge dependent, state dependent, locality dependent. It's not a U.S. law. So this bill will create an addition to the ADA that will make it so it is a law. And then you do have to follow the standards. And my guess is because WCAG is the standard, that is the standard they will be using. And then depending on what kind of website you are, what level of WCAG. So WCAG has different levels. It has an AAA, AAA standard. So I would follow this in Congress, because if you are a large company and this does pass, there will be a time very shortly after it passes where they will say you must be accessible. And then the lawyers have something literally, and Steve could talk to this, the difference between trying to sue around Title III and literally having a law that says you now must be accessible. And it's a very big difference when it comes to the lawsuits and the amount of money you might owe for not being accessible at that time. So Steve could speak to that, I'm sure.
Yeah, and we've seen something really similar with privacy in the UK and the EU, in that a lot of the law says there's no compliance it's risk-based compliance privacy in the UK and the EU, and there is no requirement. There's no one tells you do this and you are now compliant, because you've got to have relevant processes and procedures in place, and it becomes something that changes over time. What tends to happen is we get individuals complaining to the regulator, and the regulator says what they do or don't like, even though they won't tell you how to do it right in the UK, and they will take that to a judge and build a nuisance lawsuit off the back of it. But again, as far as standards go, it's all based around the idea that if you're just a brochure site, then if you do the bare minimum, then you're probably going to be okay. But the more risky use you put people's personal data to, if you don't explain it properly, if you don't put the right kind of mitigations in, if you don't provide contact details to opt out of marketing, that kind of thing, there's still an industry for it in the UK, and there's still an industry for it in the EU. So it's difficult. And I think from a legal perspective, you may say, well, we've got to have that flexibility because tech moves faster than law. But as you say, Kristine, having a standard to work back from is only going to help everybody. I think it's going to also potentially help the courts from being choked up with these lawsuits that get speculative and tend to get settled on the basis of just risk management rather than legal merit, because companies will look at them and say, I could be financially ruined by this. Let's just settle now. Let's just settle at any cost. We're seeing a very different approach. I'm not a claimant lawyer, I'm a defendant lawyer. And I've spent a lot of actually quite happy years defending nuisance claims like this. And it's a privilege to be able to do it.
One question I'd love to get all three of you to weigh in on. We'll start with Nat, since we kind of had to skip over Nat in that first question, is just packaging accessibility. There was a really good question or comment before around that it's on us as vendors to build that in as a line item and to do that proactive work. But sometimes clients will cry or complain or have comments about, well, why are you nickel and diming me? Like, what is this? So would love all three of your takes on kind of how some of those conversations have gone. What have been some of the ways that it went in a positive way? What are some of the ways where maybe it didn't quite go as well and maybe the client paid for it and came back later? We just would love your takes on that.
Sure. We've contacted everyone else that had a site. So that was a different cadence than what we're going to do going forward. Going forward, it's going to be, we list everything out. We have a hosting, monthly maintenance thing and everything. And they're actually in the proposal template that we send out, they're going to have to opt out of website accessibility compliance at that point. In terms of packaging it up, I tell them Duda and Audio is making all the money and we make nothing. That was a joke. But we say, listen, this isn't going into our pocket. This is their software here that has to be paid. And we tell people it's your appetite for risk that you're willing to take. Just $400 and some a year. Is sleeping at night worth it for you for $400 a year? So that's kind of how we package it. Yeah. One other thing I just wanted to mention, and this came up a lot. I had probably 10 people say, well, we're a small business under 15 people, and I looked up some laws and we're not liable for this. Or I'm this type of agency, I have this, we're a nonprofit, we're not liable for that. That's baloney, and I spent several $1,000s more to figure that out. It's 100% of everyone you're talking to needs ADA, and if they tell the website accessibility, and thank you, Kristine, for having me change the way I say that. It's 100%. It's all of them. And I've been reading some things, and there's a little pizza parlor that has 3 employees, and they were given a demand letter, and it cost them several $1,000s to get out from under it. So it's everybody.
Kristine, any thoughts on that?
Well, one, I love what Nat has done with the opt-in, opt-out, because then if liability in California comes back on you, you can say, we tried and they didn't go for it. So I think that's a really good way to handle it. I think, like I said earlier, most of the time you're not going to sell them on it's the right thing to do or it's the legal thing to do, because they just don't think they're going to get sued. I mean, it's been many years now, and most people don't get sued over this, right? So I do think that the way Nat's doing it, forcing them to think about it, forcing them to accept or not accept, is a good way. Plus, it's a good way to protect yourself from that. And I had another point, but I forgot it, so I'll see if I remember it before we finish.
And Steve, any from the lawyer's office, any thoughts on that?
If it's me, I'd build it into proposals and contracts, just like hosting. You know, okay. This is a cost to do business, and I think Nat's idea is fantastic. You know, there's an amazing cartoon with a lawyer in it, and his catchphrase is, "For the record, I tried," and that's a way of building this into the process. You know, if you just treat it as an absolute have to have, don't present it as optional. I think that's the problem we've had with privacy in the EU, is that it was seen as this aspirational thing. You know, privacy law has been around since 1998. Came into force. The Data Protection Act came into force in 2001 in the UK, and until the GDPR happened 5 and a bit years ago, it was, we'll get to that. People aren't that bothered. We're not going to take it too seriously. And then we had some cases that absolutely changed the game. This has to be something you build in from a risk perspective. You are helping clients manage their risk. But again, you know, lawyers telling this is one thing. Just explain to them that this is going to help them reach their best audience possible, the widest audience possible, and it's going to keep the feds off your back. And again, present not as a bonus, not as an optional thing, just as part of the project. I think absolutely has to be the way to go, and that's the only way you're really going to help change that client behavior.
Go ahead, Kristine.
Yeah, so now I remember my other point. A lot of times we do accessibility, because I did it for the federal government, and what we were doing is remediating all the federal government websites to be accessible. So it was a lot of work with a lot of archaic code. People think of accessibility as the person who can't see or can't use a computer. That's not it. As you get older, people can't see the page with the font that you chose, right? Well, if you don't have a font that's easily enlarged and contracted, well, then they can't read your site. There's color blindness that occurs as people get older. There's inability to distinguish between the hues. So part of like accessibility standards are you have to have a certain contrast, right? Because if someone gets in the 50s, 60s, 70s, they a lot of times will start to lose the ability to distinguish those contrasts. So by following these accessibility rules, you're really just making your website easier for everyone to use. And that includes a lot of people you don't think of as disabled, or you don't think that need accessibility. And then add to that, like I do SEO audits. That's my thing for the most part. And I find sites that have been around for 15 years with 50,000 images without alt text. What do you do when your site has 50,000 images that doesn't have alt text and these laws pass? How are you going to remediate that, right? So why not make sure that you start from day one, not just having your devs do it, but make sure everybody in your process understands when you add alt text, how you add alt text, when you add a link, how you add the link, things like that. When you don't use JavaScript for a link because the reader will never pick it up. There's all sorts of things in the WCAG standard that I would tell right now, get your teams together, go through it because they have an easy version to understand, and start working it into your builds, your plans, your marketing, everything, so that when I audit the site, I don't come to you and go, well, you have 50,000 images with no alt text. This is actually quite common. Now, how are you going to address that? Because that is a massive problem. Even with LLMs and AI and all that, it's still a huge thing to write all that alt text. And that is one of the first things people often get sued on, is the lack of alt text or images in a website.
So I love that you brought up with AI, because our next session is actually AI and content. So before we wrap up, I'd like for each of you to share your #1 takeaway. This was a really amazing power hour on compliance and accessibility. What's the one takeaway you want folks to think about, and how can they get in touch with you? Kristine, do you want to kick us off?
Sure. My one thing would be to get this, stop treating it as an afterthought that you only have to care about if someone sues you or something. Start treating it as part of your main website plan, in your builds, in your marketing, in your website, when you put a page together. And then getting in contact with me, LinkedIn is the best way. My last name, I'm the only me online, so it's really easy to find me. I'd have to make another me if I did something wrong to hide me. So if you just put in Kristine Schachinger, you'll find my LinkedIn is right there. So.
How about you, Nat?
Mine would be kind of what I said before, and I've done a lot of speaking in graduate schools and stuff, and I tell them something, and everyone walks away and says, I'm going to do it, but then they don't do it. And I have to stress, please get off this call and figure out how you're going to go to all of your clients and say, don't sue me. And then so you can sleep next week for the rest of your life.
And how can they get in touch with you?
I don't want to be in touch with. No.
Okay.
No, don't call Kristine. No. Nat at Olive Street Design, and a lot of people on this call have that, but you can just go to Olive Street Design and grab it. But it's Nat at Olive Street Design, and I love when I talk to hundreds of agencies, and I love it.
And Steve, what's your one takeaway?
Buy his stuff. You can be really adding value all over the place with clients if you get this kind of stuff right. And I think Nat's told a really touchy-feely lawyer story where lawyers haven't led the conversation, but they've enabled it, both from a compliance and a commercial perspective. And that's what a good relationship with a lawyer should be. We don't all chase ambulances. We're not all Lionel Hutz. Well, the only benefit of my surname being as weird as it is that you can find me pretty easily on LinkedIn. And it's been an absolute privilege to get to speak to you guys today.
Thank you, everyone, so much for investing the time. I will be joining these three in departing, and you'll be in the amazing hands of Perna Verji as she leads off the final session in this content block on AI and content. Thank you all so much for investing the time with these three, and then the earlier session on e-commerce and non-traditional views of looking at e-commerce. It has been a delight to learn and to share with you all, and hopefully you stick around for the next session.